Hello, my name is Louise Smith. I'm an associate at the employment team here at Field Seymour Parks. I'm going to run through a few of the points that we discussed at our Maternity Matters breakfast seminar on the 13th of September. Take a few moments just to outline the parameters of what we're going to discuss. Here in the UK, we have various family leave rights: maternity leave, paternity leave, adoption leave, and shared parental leave. It's a massive subject area and well beyond the parameters of one single seminar or breakfast briefing. Given the relatively low numbers of adoptions in the UK and the slow uptake of shared parental leave, which the government estimates to be around 2% of eligible individuals, we're going to focus on maternity leave. It's the most comprehensive set of benefits and protections, and it's also by far the largest issue that employers need to tackle in the family leave area. Now, notwithstanding the fact that employers deal with maternity leave, even small employers, as a day-to-day matter, it's still an area that throws up an awful lot of difficult questions for employers, generates a lot of cases because employers do still get it wrong. So we're going to, in this seminar, cover some of those tricky issues. A joint study from the Department for Business Innovation and Skills and the Equality and Human Rights Commission into the nature of pregnancy and maternity discrimination in the workplace found that as many as 3 in 4 mothers interviewed found that they felt discrimination on returning to work after having a baby or during their maternity leave period. And that just highlights why it is still such a big issue, even with large employers with dedicated HR staff. In terms of issues arising prior to leave, let's start there. Recruitment is obviously the first potential problem. The study that I referred to a few moments ago found rather surprisingly that as many as a quarter of employers thought it was reasonable to ask employees about their family plans or whether or not they had children at interview. 70% felt that employees ought to have to tell them if they were pregnant at interview. Now clearly, a candidate's pregnancy or plans to start or extend a family cannot influence and must not influence the decision to offer her a role or not. Asking those questions is irrelevant and can lead even a well-meaning employer into trouble. Even if the subsequent decision isn't discriminatory, if an employer has asked about family plans or existing children, there will be an inference that has tainted the recruitment process and the decision-making process, and an employer runs the risk of an employment tribunal claim. One case, by way of example, is the case of Chorus Hotels plc and Woodward, and this is where a job applicant was awarded £4,000 for injury to feelings as a result of discrimination during the recruitment process. At interview, first question that the applicant in question was asked was whether she had children. Her interviewer then went on very quickly to tell her that being the case, most employees who started with an existing family had left within 6 weeks, and that she ought to be realistic about the impact that taking a job as a receptionist might have on her family life. She didn't get the job. Surprisingly, I'm not sure she would have wanted it. So that's the sort of first point at which employers may come a cropper. Second issue, and it's along similar lines, is inappropriate comments about a pregnancy. Employers need to bear in mind that they're vicariously liable for the acts of their employees. So if colleagues, or worse still managers, are making inappropriate comments about a colleague's pregnancy, that can lead to a claim brought against the company for harassment and discrimination. An example by way of case law is the case of Wilson and Provincial Care Service Agency, which is a Northern Irish tribunal case. And the tribunal there found that a worker had been subjected to sex-related harassment when her ex-employer refused to give her a reference saying, well, this is what happens when you have babies. And it was the comment relating to her pregnancy that was harassment. There were obviously wider claims before the tribunal. A really tricky issue for employer is termination of employment during pregnancy. Employees are protected from dismissal or detriment on the basis of pregnancy or maternity, but that's not to say that pregnant employees can't be dismissed for an entirely unrelated reason, for example, gross misconduct. But employers would be well advised to bear in mind this inference of sex discrimination in circumstances where a tribunal might infer that a decision to dismiss is in any way related to pregnancy or maternity. The employer must be really certain that their paperwork is in order and that they're able to establish that the reason for dismissal is entirely unrelated to the pregnancy or maternity. One tricky point in particular is where you have a genuine redundancy situation. Now, on the face of it, that's not related to pregnancy. Employers need to go one step further and make sure that their selection criteria isn't tainted by any sort of discrimination, or doesn't put a pregnant employee or an employee on maternity leave to a disadvantage. In terms of pre-leave, this will be an employee who's working in the business. If she's had pregnancy-related sickness absence, for example, and one of the selection criteria is attendance, then obviously the pregnancy-related sickness absence can't be taken into account. Another area before an employee even goes on leave that an employer needs to be careful about is the whole issue of health and safety. So risk assessments, requirement to change working conditions, and suspension on medical grounds are all points that an employer needs to be wary of. Every employer is under a duty to make suitable and sufficient assessment of health and safety risks to which its employees are subjected to or exposed to while at work. And an employer should consider any risks to women of childbearing age who do work of a kind that could involve risk to their health and safety or that of their baby. Any risks that are identified must be included and managed as part of the general workplace risk assessment. That obligation is before an employee is pregnant. It's simply if you as an employer employ women of a childbearing age and there is the potential for risks should a member of your workforce become pregnant, then your obligation has already been triggered. Once you've been notified that an employee is pregnant or has given birth, or an employee is breastfeeding, you're then under an obligation to do all that you need to do, or all that is reasonable to do, to remove or prevent exposure to any significant risk that you've found. There's not a standalone obligation to perform a risk assessment, a specific risk assessment in respect of each pregnant or breastfeeding employee, but where there are potential risks, you will find as a matter of course that's the common sense approach, and you'll need to look at what you need to do in respect of that particular individual. If the risk can't be avoided, then an employer must temporarily alter the woman's working conditions or hours of work if this is reasonable and it would avoid the risk. However, employers do need to be careful about not going too far, and would be well advised to bear in mind the case of New Southern Railway Limited and Quinn. And that is, in that case, the Employment Appeal Tribunal held that changing duties or suspending an employee because they're pregnant can amount to unlawful discrimination if it's not actually necessary for health and safety reasons. And in this case, the managers had acted on the basis of their personal feelings rather than a risk assessment or any actual specific risk to the employee. They had demoted the individual in question because they were worried about the impact on her health. And one quote from the case is that, they wouldn't be able to live with themselves if something happened to the baby. The individual pregnant employee didn't want to be demoted, didn't think there was any need for it, and indeed she was right. And the Employment Appeals Tribunal found in her favour, upholding findings of discrimination and detriment. The issue of pay, if an employee's hours of work or conditions of work are changed, it is unclear because there's no provision in our domestic legislation that sets out the rate at which an employee is to be paid if she is transferred to another job that is, for example, normally on a less well-paid basis. So in those sort of instances, first thing we do is we look to the contract. If an employee is under a contract whereby she receives a fixed salary, I think it's highly unlikely that any employer would be able to reduce this without running the risk of discrimination. But the situation is less clear if the employee has no guaranteed hours or she's paid some sort of variable element such as a shift premium. In those cases, for example, if she's getting paid more to do night work and that's found to be no longer safe during her pregnancy, what happens to the shift premium? We don't know exactly, but there's some assistance from case law. The case of British Airways and Moore and another. And in this case, the Employment Appeals Tribunal upheld a finding that the transfer of pregnant air stewardesses to ground duties, where they got the same basic pay, but they lost their flying allowances because they were grounded for that temporary period. The loss wasn't insignificant. They lost something like £5,500 per year, and the Employment Tribunal and subsequently Employment Appeals Tribunal found that was less favourable terms and conditions, was discrimination. And that case goes to show that essentially the overall remuneration can't be substantially less than the employee's previous pay levels. If there's no suitable alternative work, or the employee reasonably refuses it, then the employer must suspend the employee for as long as is possible to avoid the risk. An employee who is suspended on maternity grounds is entitled to paid remuneration, and that's defined as a week's pay. If an employer has unreasonably refused suitable alternative work, then she will have lost the right to be paid during the suspension. When we talk about a week's pay, we're talking about basic pay and not elements such as commission, overtime and bonus payments. But bearing in mind the risk of discrimination, components of pay which reflect seniority, length of service or qualifications need to be maintained. Let's turn now to look at issues arising during leave, turning first of all to pay and benefits. So during statutory maternity leave, an employee is entitled to the benefit of the terms and conditions of employment which would have applied had she not been absent, except for terms as to remuneration, so wages or salary. However, it's not that simple, and this is an area that often causes confusion for employers. First tricky point arises around perks such as a company car and car allowance. The basic rule is if an employee is only allowed to use a car for business use, or a mobile phone or a laptop computer, then it's not considered a benefit and there's no obligation to continue to provide it during maternity leave. However, if an employee is entitled to use the car or other perk for personal use, then it's a benefit in kind, and she is entitled to continue to use it during maternity leave. In terms of a car allowance, there's still a division of opinion into which category car allowances fall. Is it a benefit other than wages or salary, or does it count as salary and remuneration? There's no clearly defined answer, but if one thinks that when an employee qualifies for statutory maternity pay, any payment that's liable for national insurance contributions, such as car allowance, falls to be taken into account when calculating her maternity pay, then it seems to me that if you then also maintained car allowance as a separate benefit, the employee would be essentially having a degree of double payment, double recovery, which would suggest that car allowance should be treated as wages and salary. Next thing to look at is annual leave. So women on maternity leave continue to accrue their statutory paid annual leave entitlement under the working time regulations, together with any additional contractual entitlement they have. We've had a whole raft of European case law in respect of holiday relating to maternity and sickness absences. What's come out of that case law is the position that an employee on maternity leave can't take her annual leave, and therefore she must be given the opportunity to take this holiday, including bank holidays and other compulsory shutdown periods, at another time. And that may well mean allowing her to carry that holiday over. That's the position where it comes to statutory entitlement to holiday. That's what the case law has dealt with. It's unclear whether contractual entitlement, additional contractual entitlement, will be dealt with in the same way, but the safest position is for employers to assume that it will be. So childcare vouchers. Childcare vouchers can be provided to employees on top of their normal salary or by way of salary sacrifice. So that's where the employee agrees to a variation of their contract terms, reducing their salary in order to receive the vouchers. And the question is whether vouchers received in that way are a non-cash benefit or part of the employee's salary. Recent-ish case of Peninsula Business Services Limited and Donaldson, Employment Appeal Tribunal held that childcare vouchers provided under a salary sacrifice scheme are diverted salary, part of employees' remuneration, and do not therefore have to be provided during maternity leave. However, note of caution, this was a decision that the Employment Appeal Tribunal said they found rather tentatively, and in fact went against HMRC's view, which was that they were non-cash benefits that ought to be continued during maternity leave. As a result, employers may choose to continue to provide childcare vouchers despite the Peninsula decision. Turning now to pay rises. Obviously, if an employee would be entitled to a pay rise, but for the fact she's on maternity leave, she remains entitled to that pay rise. But an interesting quirk is that statutory maternity pay is based on the employee's average earnings during an 8-week reference period. Statutory maternity regulations expressly provide that if a subsequent pay rise kicks into force, the maternity pay has to be backdated to the start of the reference period, so that if an employee is awarded a pay rise on even the last day of her statutory maternity leave, her whole statutory maternity pay entitlement from day one has to be recalculated on the basis of the new figures and a top-up payment made. In terms of bonuses, so bonuses will clearly constitute wages or salary in most instances, and the general rule is that employees on maternity leave must be paid the same bonus as any other employee for the period before they go on maternity leave and during the compulsory 2-week maternity leave period. But they're not entitled to a bonus in respect of the remaining period of their maternity leave. So in the Hoyland and Asda case, the Employment Appeals Tribunal confirmed that where a contractual bonus was paid to reward employees for work already performed and their continued contribution during the year, you could pro-rata the bonus to reflect the period where an employee is absent on maternity leave and that didn't amount to sex discrimination or pregnancy-related detriment. Employers might want to bear in mind the situation could change if a bonus is perhaps paid to employees regardless of whether or not they've been in employment for the entire bonus year, or is paid out at Christmas as a we're lovely employers, have a lovely Christmas, rather than as a reward for work done. And in those situations, actually, the safest thing to do is to include your employees on maternity leave in those bonus provisions. Pensions, I'm going to cover this very lightly. The Equality Act 2010 imposes a maternity equality rule in respect of occupational pension schemes. So that means during periods of ordinary maternity leave and paid additional maternity leave, so that's in essence the first 39 weeks of any maternity leave period, pension contributions will continue as they had before, but the employee's contributions are based on her maternity pay. Employer must continue to provide benefits on the basis of the pay that the individual would have received had she been working normally. Bear in mind that in the context of a salary related scheme such as a final salary pension scheme, an employee must be allowed to continue to accrue benefits as if she was working normally, and therefore where her contributions are calculated by reference to the amount of pay or SMP she's receiving, the employers must make good the shortfall. That's not quite so clear cut with a normal occupational money purchase scheme, and most employers take the view that they're not required to make good any shortfall in relation to the employee's contributions. That being said, it's good practice for employers to remind employees that they might wish to increase their contributions whilst on leave to make good any shortfall. In terms of salary sacrifice, one point to pick up is it's common for employers to enter into salary sacrifice arrangements where they agree to increase employer pension contributions, and as a result the employees take a reduction in salary. The accepted position was that the employer must maintain those levels of pension contributions during ordinary maternity leave and the paid element of additional maternity leave. Again, it's those first 39 weeks. We spoke in respect of childcare vouchers about the Peninsula decision, and questions have been raised as to whether that changes the pensions position. And in short, I don't think it does, or certainly the safest position for employers to adopt is that it doesn't. When we talk about childcare vouchers and the decision in Peninsula, that was very much decided on the basis of what is remuneration, that limited concept. It's different when it comes to pensions because Section 75 of the Equality Act 2010 specifically requires accrual of pension rights to continue during periods of ordinary maternity leave and paid additional maternity leave. So most likely employer pension contributions must continue in full as if the employee was at work. Let's look at enhanced shared parental pay. This is a relatively new issue for employers to grapple with, and it's still unclear whether companies with enhanced maternity packages are obliged to match those benefits for anyone taking shared parental leave. There's no statutory requirement for employers to do so, and indeed the government considers that it is not necessary. From a direct discrimination point of view, that seems right. Since both men and women can take shared parental leave, arguments based on direct discrimination seem unlikely to succeed. An employer can and has successfully argued that in that situation, the correct comparator for a man on shared parental leave is not a woman on maternity leave, but a woman on shared parental leave who will, of course, be receiving the same terms and benefits. Indirect discrimination is still a possibility. If an employer pays enhanced pay only to women on maternity leave, that is a provision, criterion or practice which all men and some women can't comply with and are put at a disadvantage in respect of that provision, put to a disadvantage in respect of that provision. So it's therefore, on the face of it, potentially indirectly discriminatory. That's not to say that an employer wouldn't be able to objectively justify such a policy, and we haven't had a clear decision on it yet. In the case of Hextall and Chief Constable of Leicestershire Police, an employment tribunal had dismissed claims of direct and indirect sex discrimination, which had been brought by a police officer who had been paid only statutory shared parental pay, where fellow employees on maternity leave were paid 18 weeks of full pay under an enhanced maternity package. The Employment Appeals Tribunal have since said that the tribunal at first instance got it wrong in respect of how they approached the indirect discrimination claim, and they have remitted the case to a new tribunal to be heard again. The subsequent decision will hopefully provide some clarity on indirect discrimination on this point. Let's turn now to keeping in touch. There is explicit provision for reasonable contact during maternity leave and adoption leave, as well as more formal keeping in touch days. An employer may make reasonable contact from time to time during an employee's maternity leave. That may allow the employer and employee to discuss arrangements for returning to work or keep the employee informed of important developments at work. But it's a difficult balancing act for employers, and what's reasonable will depend on the individual circumstances and the attitude of the employee. It's therefore good practice for employers to have a discussion before an employee goes on maternity leave to discuss how frequently and by what method she'd like to be contacted. In addition to sort of general catch-ups, the employers need to bear in mind that an employee on maternity leave must, of course, be made aware of any promotion opportunities or vacancies that might arise during maternity leave. One case on this point, Visa International Service Association and Paul, demonstrates that where an employee hadn't been notified of a potential vacancy that she would have been interested in while she was on maternity leave, that can and did on these facts amount to maternity-related detriment and constructive unfair dismissal. But of course, whilst you want to keep your employees informed, you can't place pressure on an employee to take part in any events or take any specific action while she's on maternity leave. Again, the other point to bear in mind though is if you have proposed redundancies or reorganisations and you are looking at commencing a consultation exercise, you need to ensure that your employees on maternity leave are included within that exercise, or at least given the opportunity to be included within the exercise if they so wish. I'll be honest, I've had lots of very good employer clients who have forgotten about employees on maternity leave until they were just about to reach final decisions, and we've had to backtrack on the consultation exercise. So it's really important that they're not left out of the loop. Just to finish off that point, as both parties may agree for women to work up to 10 days as keeping in touch days that won't bring her maternity leave to an end. That's different to reasonable contact, because these are days where a woman's actually coming in to work for the employer to undertake a specific task. Normally pay will be at the contractual rate of pay, depending on the work done and whatever's agreed between the parties, and that can be offset against statutory maternity pay if the woman's still in receipt of that. Disciplinary issues. The fact that an employee is on maternity leave is no block to an employer investigating potential disciplinary matters that come to its attention if it needs to. Obviously, employers who do pursue disciplinary issues will need to take care to ensure that they avoid claims for discrimination. A full and proper process should be followed, with employers taking care to properly document their procedure and decision-making process. Also need to make sure that when you're undertaking that process, an employee on maternity leave isn't subjected to a disadvantage as a result of her leave. So you will need to be more accommodating in terms of how and when you conduct meetings. You can't compel an employee on maternity leave to attend a meeting, and therefore you may need to take a more flexible approach to how you deal with these issues in general. Redundancy on maternity leave is another tricky area for employers. If a redundancy situation arises during an employee's maternity leave and it is not practicable by reason of redundancy to continue to employ her, the employee is entitled to be offered a suitable alternative vacancy where one exists. This effectively gives an employee on maternity leave priority over other employees also at risk of redundancy, and is a rare example of lawful positive discrimination. If the employee does not comply with this requirement, the employee will have a claim for automatically unfair dismissal. Employers do need to note, however, that this additional protection is only triggered once the employee has been provisionally selected for redundancy. It's not something that needs or indeed should be factored into the redundancy selection process itself. Case of Eversheds Legal Services Limited and Dublin, the firm's decision to artificially inflate a female employee's score in respect of one of the selection criteria on the basis that she was on maternity leave amounted to direct sex discrimination. The employer's going far further than is reasonably necessary to avoid any disadvantage to the woman arising because she's on maternity leave, and is therefore at the risk of committing discrimination against male employees also in the pool for redundancy. Bear in mind also that when you're looking at suitable alternative vacancies, the new contract offered to the employee must be such that the work to be done is both suitable and appropriate for her to do in the circumstances, and the capacity and place in which she's employed and the other terms and conditions of employment are not substantially less favourable to her than if she'd been continued to be employed in her old job. if the employee refuses a suitable offer, her dismissal for redundancy, notwithstanding the fact she's on maternity leave, is likely to be fair. But if she unreasonably refuses the offer, she will lose her right to a redundancy payment. Just to finish off on talking about redundancies and disciplinary issues, there's a quirky point in relation to notice and maternity pay entitlement where an employee is dismissed on maternity leave. So the employer must pay the employee her normal full pay during the statutory notice period, and the employer can offset maternity pay against this full pay provision. However, where the employee's contract of employment requires the employer to give her at least 1 week more than the statutory minimum notice to terminate the contract of employment, then she's only entitled to statutory maternity pay. So an employee who has the normal statutory notice provisions in the contract will be entitled to notice at full pay if dismissed during maternity leave. If they have enhanced contractual notice rights, so that they're entitled to 6 months notice or what have you, then actually they're in a worse position in respect of their pay during that period, because they will only be paid their statutory maternity pay. It's also worth bearing in mind that the entitlement to statutory maternity pay crystallises at the 15th week before the expected week of childbirth. So if your employee is dismissed during her maternity leave, she's still entitled to be paid this entitlement. She's already earned it. Employers aren't in the clear once employees have returned to work. There are a number of other issues that you need to bear in mind moving forward. Perhaps the most common issue is that of flexible working. Flexible working isn't only a maternity family leave related issue. Any employee with 26 weeks continuous service is entitled to request flexible working for any reason. Employer must deal with the request in a reasonable manner and notify the outcome to the employee within a 3-month period. This statutory regime is underpinned by an ACAS code of practice. The employee under the statutory scheme may only make 1 request in any 12-month period, and there are 8 specific grounds for rejecting a request, and these are the only grounds that can be relied upon. Examples would be detrimental impact on quality, burden of additional costs, planned structural changes. And in relation to a claim solely based on breach of the flexible working legislation, and a tribunal will not look behind, generally, the statutory reason for refusal. But employers need to be aware that employees may still have recourse outside of the statutory scheme. Ever since the 1998 case of London Underground Limited versus Edwards, which noted that women are more likely than men to be single parents caring for children, so that a policy requiring employees to work full-time is more it's going to have a disproportionate impact on women. It's clear that employers face the risk of a claim for indirect discrimination if they can't objectively justify the decision to refuse a mother's request for flexible working. And that's where indirect discrimination claims relating to flexible working differ from claims relating to the flexible working legislation itself, is most usefully demonstrated in the case of Caswell and Advanced Travel Partners UK Limited. And in that case, a tribunal rejected a claim in respect of the statutory right to request flexible working, but upheld an indirect sex discrimination claim. The employer in this case had decided that a claimant working fewer hours would have a potentially detrimental effect on customer service. And the tribunal in that case said that answer might satisfy the Employment Rights Act provisions dealing with flexible working, but it's not a reason that has any meaning or suggests that the manager approached the issue with an open mind, and it, effectively it didn't meet the bar of objectively justifying the treatment. But it works both ways. The case of Walkinshaw and John Martin Group, an interesting direct discrimination case where a man had been denied the right to work part-time following his wife's maternity leave, and he claimed direct discrimination because many women in his firm were regularly allowed to work part-time, and the tribunal accepted that his request had been refused because he was a man, and that a woman in the same post as him with the same responsibilities, same hours, same duties would have been afforded the opportunity to perform the role on a part-time basis. Another issue for employers to bear in mind on an employee's return after maternity leave are issues surrounding breastfeeding. So firstly, there are the health and safety requirements that we addressed briefly at the beginning of the talk about health and safety issues. An employer is required to assess the risk to its employees, including employees who are breastfeeding, and to do what's reasonably practicable to control those risks. There are additional requirements that require employees to provide suitable facilities for breastfeeding mothers to rest, including facilities to lie down and provide adequate rest and food breaks. In terms of breastfeeding at work, and that is both feeding and expressing, there's no statutory right to time off for breastfeeding. There's also no legislation which requires provision of facilities, but guidance from Health and Safety Executive is that other facilities such as private clean environment for expressing, milk for storing, expressed milk, etc. should be provided. The Equality Act under section 13(6)(a) provides that it's direct discrimination to treat a woman less favourably because she is breastfeeding, but discrimination at work is expressly excluded from that breastfeeding specific provision. That being said, a breastfeeding employee can of course continue to rely on protection from sex discrimination. And if an employer refuses to allow a woman the flexibility she may need to breastfeed or express milk, this may be indirectly discriminatory unless the employer can objectively justify their actions. And that was evidenced in the case of McFarlane and another versus EasyJet Airline Company Limited. And in that case, the Employment Tribunal upheld a complaint of indirect discrimination from the airline, arising from the airline's refusal to allow certain flexible working arrangements for breastfeeding. And in this case, 2 crew members had essentially asked not to be put on shifts of over 8 hours so that they could express more regularly and reduce their risk of health problems. EasyJet had refused the request, saying that they couldn't possibly do that. They needed to keep to their flight schedules and avoid delays, but having given that reason, weren't actually able to give any evidence as to how the flexible working arrangements might cause them operational difficulties. In terms of final point really I wanted to cover is just dealing with sickness after maternity leave. So following the end of maternity leave, an employee who is unwell should follow their employer's normal sickness absence procedures and will be entitled to any sick pay in the normal way. Case of Brown and Rentokil Limited, the ECJ held that where an employee is ill, even as a result of pregnancy or childbirth, after the end of her maternity leave, there's no discrimination on the grounds of sex if she is then treated in the same way as a male worker. Only slight caveat to that is that where there is a redundancy situation on an employee's return to work and an employer is looking at selection criteria that touch on absence, for example, once again, sickness absence during that protected period of maternity leave and pregnancy must be disregarded. That's really all of the points that I wanted to cover. If you've got any questions about the issues that I've covered, or you'd like to attend one of our breakfast briefings in person, please do get in touch, and my contact details will be found below. Many thanks.